Hi everyone, welcome back to my channel. I am Teacher Ilona. On my channel, I do videos on business studies and business management for grade 10, 11 and 12. In today's video, we'll be looking at the Labor Relations Act. So stay tuned and join. If you haven't already, please subscribe to my channel and hit that like button. So before we get started, I would just like to mention that I have received these notes from the Department of Education within South Africa, and it's for the subject business studies. I in no way take credit for the content written in these slides. I have made use of this content as it is directly related to the content that the students are making use of in their class and while they are studying. And I ensure to use these slides and this content to make sure that it is up to date and it is exactly the same content that the students are learning in class. So, the Labor Relations Act, let's get started. The content covered in this video today will be the following. We will be looking at the purpose of the Labor Relations Act, the impact of the Labor Relations Act, both positive sides and negative sides. We'll also be looking at discriminatory actions, penalties for non-compliance, a way that a business can comply, and the rights of the employers, and then the rights of the employees. When we look at the purpose for the Labor Relations Act, why was this act created? What is the purpose? It provides a framework or structure for labor relations between employers and employees. So this is the framework, the structure that they can work off. It promotes collective bargaining at the workplace. It promotes workplace forums to accommodate employees in decision-making, whereas in the past, not all employees were involved in decision-making. It establishes labor courts and labor appeal courts. It provides simple procedures for the registration of trade unions and employer organizations. It provides the right to lock out by the employers as a reaction of lengthy strikes. It promotes fair labor practice between employers and employees, just to make sure that everything's fair and everything that they're doing is in a fair and well-presented manner. It clarifies the transfer of employment contracts between the existing and the new employers. It advances economic development, social justice, labor peace to ensure that the workplace maintains the basic rights of the employees. And the basic rights we will be looking at towards the end of the video. Establishes the Commission of Conciliation, Mediation and Arbitration, or the CCMA, for dispute resolutions. So it has established the CCMA. So if there is a dispute, if there is an issue between the employee and the employer, instead of the employee trying to resolve it themselves, they can just go to the CCMA and have that resolved. So this act, one of their purposes was to establish this kind of system. Then we're looking at the impact of the LRA on businesses. We're going to be first looking at the positive or the advantages. It promotes a healthy relationship between employer and employees in this way because they both have their own rights. So it protects that relationship. It promotes the rights of businesses in labor-related issues. Labor disputes are settled quicker and less expensive because sometimes it can be a dispute that can go on forever and it can be very lengthy as well as very costly. But within this act, it is less expensive. It protects employers who embark on lawful lockouts when negotiations between parties fail. So the lockout virtually means that they physically lock out those employees because they might feel that they might be a danger to the company or a danger to the image. So this act protects the employers when they want to lock out their employees because there might be a negotiation that had failed. The LRA provides for the principles of collective bargaining and puts structures in place with which disputes in the workplace can be settled. Okay, as we've mentioned before, it's a way that we can resolve conflict and have things settled. It provides a specific guidelines for employers on correct and fair disciplinary procedures. So it provides the steps. So when there has been an offense, for example, an employee keeps arriving to work and they are not professionally dressed. They're meant to have a uniform on, and they're coming to work without their uniform, for example, or they're coming late. There is a certain disciplinary procedure that needs to be in place. There has to be verbal warnings, written warnings, and there has to be a whole meeting with these disputes as well to prove that someone was trying to resolve it before they can actually let go of their employee due to this dispute. So this Act provides the guidelines to make sure that the disciplinary procedures are fairly handled. Employers and employees have guidelines regarding to correct and fair dismissal procedures. As I said, there's a correct dismissal procedure. So for example, if an employee comes late once, you can't let them go or fire them because there is a certain procedure that needs to be in place. You have to give them a verbal warning. They have to be aware of it. You've had to try and find alternatives and try and find out from their situation. So it provides mechanisms such as the statutory councils, collective bargaining, and the CCMA. Employers are entitled to compensation from the Labour Court if they suffer damages as a result of unprotected strikes. Unprotected strikes, such as they wrote a letter to the company to state that they would like to have a strike, and it has to be signed off and it has to be allowed, therefore making it legal. But throughout the strike, some of the employees are feeling that they're not being heard, so they start throwing some rocks and they try and start burning some of the materials around the company, and they try and start vandalizing the building. Those damages that are suffered, the Labour Court can provide compensation, therefore, and that's definitely a positive. Workplace forums can add value to businesses if it functions properly. Now we move on to the negatives or the disadvantages that this act has on the business. Productivity may decrease if employees are allowed to participate in the activities of trade unions during working time. So with the trade unions, they are allowed to collect data and speak to the employees, and this is during working time. This is a disadvantage because productivity decreases. That person is away talking to the trade union for 5 hours. That's 5 hours of work lost that you can't make back. Cost of labor increases because of these legal strikes. So while you have your whole admin department striking, you do not have your admin department working. Therefore, you might need to get in people for that day to cover their work and to do their work while these people are striking. Reduce global competitiveness due to lower productivity. So to remain globally competitive, it's going to reduce because your people are always either striking or their productivity is low because they're striking, because of the trade unions. Employers might have to disclose information about the workplace issues to the union representatives that could be the core of the competitive advantage. So they might need to give away sensitive information and information that is very private to them, to these trade unions, to the union representative, in order to resolve the issues, which obviously then it could have a decrease on their competitive advantage because they're busy giving out all these trade secrets. Employers may not dismiss employees at all, as procedures have to be followed. So as I mentioned, you can't just dismiss an employee if they're late for work once. You have to follow the procedures and you have to provide proof. And with the warnings, it has to be specific. It has to be per offense. If you come late and they give you a warning, it has to be the warning for being late. If you come to work and you are not dressed appropriately, that's another offense. So you have to get 3 written warnings plus a verbal warning for being late. If you come to work dressed unprofessionally, that's a different case that comes under its own written warnings. So because of that, it can be a disadvantage for the company in that way that all procedures have to be followed. Some businesses may feel that the Act gives employees too much power as it creates a lengthy procedure. As I mentioned, there's a whole lengthy procedure. Therefore, the employees do have a significant amount of power when it comes to this. And for example, with this is consulting with workplace forums. Employers may not get a court interdict to stop a strike. So that's also an issue. If you have, as I mentioned, your whole admin department striking, you cannot get a letter from the court to state that you would like the strike to stop. You will need to meet their demands and handle the dispute. And obviously, this can be a disadvantage to the business because they're losing days of productivity and they're losing days of work being done. Strike actions always result in losses of production in which employers may not claim back. As I mentioned, your sales team, admin team goes on strike for 2 weeks. You cannot claim back for that. It is lost time, and it's time that you won't get back from that. Some trade unions may not promote the mandate of their members, but embark on industrial action, which is harmful to the labor relations between employers and employees. Looking further into the disadvantages and the negatives, many employees and employers do not understand or respect the Labor Relations Act. That can be a big disadvantage. Labor disputes and bargaining council processes become disruptive, time-consuming, and they lead to a decrease in productivity in the business. I've mentioned this before as well. Many employees take advantage of the right to strike without acknowledging their responsibilities. So they feel that they have a right to strike, and in this way, they're not acknowledging their responsibilities. They need to get work done. They have deadlines. They have things to get done, but they believe they have the right to strike, and therefore this can be a huge disadvantage to the company itself. Now we're going to look at the discriminatory actions according to the Labor Relations Act. So promoting the interest of one trade union over another in the workplace, discrimination, it's not allowed. You have to promote all of them. You have to make them all available to your employees. You can't promote one over the other. Dismissing employees from a racial group engaged in an illegal strike action, that's also considered discrimination. Allowing only a particular gender or age group to be part of the workplace forums. So if you say that only the males are allowed to join these workplace forums, that is not allowed. It has to be available for all employees, no matter their age or their gender. Granting leaves to attend union meetings, activities, programs only to site stewards, union representatives. With this one, they are referring to, you're only allowing the site stewards or the union representatives to attend these meetings. That is also discrimination. All of your employees that are part of that trade union have to be allowed to attend these programs and these activities. But as we mentioned, that can be a disadvantage because it's taking away work time. Penalties for non-compliance. So if a company does not comply with this act, what penalties do they face? The employer may be forced to enter into a dispute resolution process. So there will be a whole discussion with the CCMA, and there will be a whole discussion on this to try and resolve the conflict or the dispute. Businesses will be fined if they fail to comply with the agreements reached during the dispute resolution process. So they can face a fine if they do not comply with the agreements that are reached. So they go to the dispute, and there are certain agreements that are reached. Okay, we expect this from the business, we expect this from the employees, we expect this from the trade union. They have to carry out those agreements. If not, they stand a chance to be fined. Businesses that fail to comply with this act may risk financial costs. Therefore, legal, CCMA fees, fines. So if they do not comply with this act, so if you have an example with this one, if an employee comes late constantly and you have warned them, so you've given a verbal warning, but no written warnings were given. And one day you just say to them, listen, we are dismissing you because you keep coming late for work. That employee can then go to the CCMA and dispute this and say, yes, I understand I was late, but I was never given a written warning. Nevertheless, I was never given 3 written warnings as what I'm supposed to be receiving. And therefore, they can dispute that. And in that case, if there wasn't proof that written warnings were given, then the company will have to pay a fine or fees for this case, which then is a big cost for the company itself. So now we've looked at the penalties. What are the ways that businesses can comply with the Labour Relations Act? Businesses must allow employees to form trade unions, participate in union activities, and legal strikes. So they need to allow that. Again, if they don't, as we mentioned, it's then the penalty for non-compliance. They need to allow and support the establishment of workplace forums. Employees should not be unfairly or illegally dismissed, as we've mentioned. Employers should not breach or ignore any collective agreements. And they need to disclose all relevant information required by the trade union representative so that they can do their jobs effectively. We are now going to look at the rights of the employers and then the rights of the employees according to the Labour Relations Act. So first, we're looking at the rights of the employers. Employers have the right to lock out employees who engage in unprotected, illegal strikes or labour action. So the employers have the right to lock out employees who are engaging in unprotected, illegal strikes and labour actions. So if they are a harm to the business and they are trying to damage the building, the employers have the right to lock them out. They form employer organizations, they have the right to do that. They have the right to form a bargaining council for collective bargaining purposes. They have the right to dismiss employees who are engaged in an unprotected strike, misconduct such as intimidation or violence during a strike action. That is the employer's right to do so. They have a right not to pay an employee who has taken part in a protected strike for services or work they did not do during the strike. So they have a right not to pay these employees. If you want to go strike, then you go strike, but then you do not get paid for the work done. So going back to the disadvantages, it is still a disadvantage because that work is still not being done. They may not be getting paid for it, but that work's still not getting done. You're still missing out on that work, that the productivity that those employees would have been doing. But the employer does have the right not to pay them if they're involved in a protected strike, it says. Okay. Now we look at what are the rights of the employees. The employees may join a trade union of their choice. So what we mentioned with the discrimination actions is that they favor one versus the other. That's not allowed. The employees may join the trade union of their choosing, of their choice. So if they prefer one over the other, that is their choice, and they have the right to do so according to the Labour Relations Act. They have the right to request a trade union representative to assist or represent employees in a grievance disciplinary hearing. So they have the right, if that employee goes into a disciplinary hearing, they have the right, because they're part of a trade union, to ask for a representative from that trade union to represent them and to assist them, almost as if a lawyer would assist someone in court. They have the right to do that. Trade union representatives may take reasonable time off with pay to attend the trade union duties. So that's their right. They can, if it's a representative, obviously. So if it's a representative, they are allowed to go and do these duties and attend the meetings, and they have to get pay for it. So they're allowed the time off and the pay. That's their right. Only if they are a trade union representative. Embark on legal strikes as a remedy for grievances. They are allowed to do that. They're allowed to embark on a legal strike. Legal is when you do not harm the business and become violent. They are allowed to have a legal strike if they disagree with something. They don't agree with the pay, they're allowed to strike for it. It's their right. They have the right to refer unresolved workplace disputes to the CCMA. As I mentioned, if they feel there is a dispute in the workplace and they want to have it resolved, they have the right to go to the CCMA and have it resolved. They have the right to refer unresolved CCMA dispute to the Labour Court of Appeal. So if it is not resolved by the CCMA, then they're allowed to take a step forward and go to the Labour Court themselves. They have this right. There is nothing their employers can do. This is their employees' right to first go to the CCMA for the dispute. If it's not resolved, they have the right to take it further to go to the Labour Court. All right, guys, so we have reached the end of the video. I am so happy I did this video. There's loads of content in this, packed in, and I really hope that you guys were taking notes and taking down those examples, and you're more than welcome to rewatch the video and pause at any moment where you want to take down a note, or go listen to something that you might not have understood. I hope you enjoyed this video. I hope I made it as exciting as possible. I know the legislations can be a little bit difficult, and it's difficult to make them exciting because they are just facts. It's the facts, and those are the facts. I hope you guys did enjoy this video. If you haven't already, please remember to like this video and to subscribe to my channel. Tap that notification bell if you would like to be informed and alerted when I upload new videos, and please post any videos, suggestions that you would like me to do, and I will definitely add them to my calendar. I have added a few videos to my calendar, which I will be making the slides for and uploading those in a few weeks' time. So please, and if there's any questions you have at any moment, you can contact me on Teacher Ilona on Facebook, as well as Instagram. You're more than welcome to, and you can also put a comment down below, and I'll be glad to answer any questions that you guys may have and any suggestions that you guys may have. Thank you so much, and I can't wait to see you guys in the next video. Happy studying, and let's love business studies together. Bye.